So what I want to talk about today is the role that confession evidence plays in the United States criminal justice system. So I'm going to identify a particular structural role that it plays, and I'm going to take a very in-depth look at that in the criminal justice system in the United States. But the structure that I identify is not unique to the US criminal justice system. It just gives a particularly powerful case study. So the phenomenon itself that I identify will be generalizable. Okay, so in the criminal justice system in the United States, and I'm going to leave that off from now on so we can just assume that that's what I'm talking about, confessions have long been considered the gold standard in evidence. So for instance, the United States Supreme Court recognized that confession evidence is perhaps the most powerful evidence of guilt admissible in court. And this is from Miranda versus Arizona in 1966. So powerful, in fact, that the introduction of a confession makes the other aspects of a trial in court superfluous, and the real trial, for all practical purposes, occurs when the confession is obtained. So one way to think about this is that a confession in the criminal justice system is not regarded as, say, a shell casing or a fingerprint. It's not the sort of thing that is regarded as a piece of evidence so that the investigation continues. It is regarded as the closure of the investigation. So oftentimes, more often than not, when a confession is obtained, the investigation stops, and then they start building the case for the prosecution. But an immediate problem arises for this gold standard when the prevalence of false confessions is taken into account. So today we're going to be understanding a false confession as an admission to a criminal act, usually accompanied by a narrative of how and why the crime occurred that the confessor did not commit. So since 1989, there have been 367 post-conviction DNA exonerations in the United States, and 28% of these involved false confessions. And it's important to note that this number is going to be fairly low, the 367, because, for instance, many defendants don't have the resources to afford DNA testing. They don't have attorneys who take these cases on pro bono. Judges might reject the request for DNA testing, and so on. So confessions involve everything from minor infractions to detailed accounts of violent crimes. I think when people think about falsely confessing to something that they didn't do themselves, they often think, oh, this would be, were I to ever do this, it would be over something fairly minor. But when you look at the data in the largest sample ever studied, Drizin and Leo analyzed 125 cases of proven false confessions and between 1971 and 2002, and found that 81% actually occurred in murder cases, followed by rape and arson. So the bulk of proven false confessions actually take place in murder cases. So what I want to do today is I want to take a very close look at false confessions, and I'm going to show that they provide a unique and compelling challenge to the current tools that we're using across disciplines to understand a phenomenon called testimonial injustice. Maybe you've talked about that in the series, but I'm going to explain what that amounts to. And I think one of the things we're going to see by looking at this close analysis is that philosophy and the way that we're understanding this particular kind of injustice can benefit by taking a very close look at some of the empirical work in the social sciences and in criminal law. But at the same time, the social sciences and criminal law can benefit from the normative tools that this phenomenon of testimonial injustice provides. So I think that it provides a very useful framework for us to understand false confessions across all of these dimensions. So here's the roadmap. I'm first going to show that in the criminal justice system in the US, confession evidence often swamps all other evidence. And I'm going to argue that we can't make sense out of this swamping effect that confession evidence has by looking merely at speakers or people who offer testimony, just regular run-of-the-mill testimony. Okay? Not testimony only in a criminal court or testimony as it's often used formally, but just us reporting anything. We can't make sense out of this swamping effect that confession evidence has by looking simply at people getting less credibility than they deserve. And that's the way testimonial injustice is typically understood. And so I'm going to conclude that the way that we understand this kind of injustice that speakers suffer needs to undergo a radical expansion to include what I call agential testimonial injustice. And what that amounts to is a kind of injustice where someone gets more credibility than they deserve, but their testimony has been extracted under conditions of coercion or manipulation or deception. And then, when their agency has been subverted, then that testimony is given this massive excess of credibility. So a very helpful slogan is to think of extraction and excess, right? The testimony is extracted from people in ways that undermine their agency. And then that is regarded in a crucial respect as representing their truest self. Okay? And I'm going to say that that is a unique kind of wrong that speakers can suffer. Okay, so I want to spend a little bit of time getting a handle on some of the facts and some of the mechanisms that give rise to false confessions. And these mechanisms are going to play a critical role in the philosophical analysis we're going to look at. Okay? So there are typically two, broadly speaking, different kinds of factors that make it likely or more likely that someone is going to falsely confess to a crime that they didn't commit. The first kind are called situational factors, and I'm going to highlight a few that are most kind of prevalent. The first is the length of the interrogation. Okay? So according to guidelines that have been outlined, it's advised that single interrogation sessions should not exceed 4 hours. But in that kind of largest sample of proven false confessions, it was found that 34% of the interrogation sessions lasted 6 to 12 hours, 39% lasted 12 to 24 hours, and the mean was 16.3 hours. Okay. Along with these lengthy interrogation sessions often come isolation and sleep deprivation. Okay. So it's not uncommon to isolate people from their loved ones. Okay. I became interested in this topic because I have founded and I direct the only degree granting program in Illinois that confers degrees to people who are incarcerated. And one of my students, when he was 15 years old, the police had asked his father to bring him to the police station to view a lineup of suspects in a murder case. And they immediately separated him at 15 years old from his father, told his father that they were only going to be showing him a lineup, and began interrogating him. And within several hours, he falsely confessed to the murder himself. And now he's in his 30s and he's still incarcerated. And so that was one of the first things. He was 15, he was a child, and they immediately isolated him from his father. And when someone is isolated from a support system, they're far more likely to succumb to the interrogation techniques. So also, along with these lengthy interrogation sessions, often come sleep deprivation, which strongly impairs human functioning. This is perhaps one of the most powerful, and I know that the United States, there are lots of countries, and I believe the UK is one of them, where this is not permissible, but in the United States, it is legal to present false evidence to suspects. Okay? Meaning, I can call you into the interrogation room and I can say, we have your fingerprints on the murder weapon. We found your DNA at the scene of the crime. And I can tell you that if I'm a police officer, if I'm interrogating you, even though it's false. And so usually when people are presented with this false evidence, and this is not something that's widely known in the United States. It's not as though everybody knows that it's legal to present false evidence. So people oftentimes feel that they're kind of weighed down by the burden of the evidence against them and feel that, well, I mean, I don't really know how to explain this. So here's a well-known case, the case study of Marty Tankleff. In 1989, Marty Tankleff was accused at the age of 17 of murdering his parents, despite the complete absence of evidence against him. Tankleff vehemently denied the charges for several hours until his interrogator told him that his hair was found within his mother's grasp, that a humidity test indicated he had showered, hence the presence of only one spot of blood on his shoulder, and that his hospitalized father had emerged from his coma to say that Marty was his assailant, all of which were untrue. His father actually never regained consciousness and died shortly thereafter. So Tancliffe is 17 years old. He just has experienced an incredible trauma. Both of his parents have been murdered. And then the interrogators tell him that his own father pointed the finger at him. Okay? So following all of this, he became disoriented. He confessed, but then he immediately recanted. And solely on the basis of that confession, he was convicted. And his conviction was vacated. The charges were dismissed, but only 19 years later. He is now a practicing attorney, but obviously he was incarcerated, wrongly convicted and incarcerated for the murder of his parents. It's also supported by self-report studies where people who have falsely confessed report that the weight of the evidence is oftentimes what led them to do so. There's also what's called minimization tactics, and there are 3 different kinds. Those that minimize the moral consequences of confessing, those that minimize the psychological consequences, and those that minimize the legal consequences. So in the first case, interrogators might say, look, I would have done the same thing. I completely understand. It's probably, what did you find out that she was cheating on you? And they might try to kind of diminish the moral kind of wrongness of it. The second one is to diminish the psychological wrongness. So they'll say, I bet it was an accident. Maybe it was a crime of passion. The third is to minimize the legal consequences. So I was recently on a panel on false confessions with someone who had falsely confessed, and he described how his interrogators had told him that his mother would actually see him be executed because they would go for the death penalty. But if he confessed, they wouldn't go for the death penalty. So he said the thought of his mother seeing him be executed is what led him to do so. So they minimized and kind of like, look, I mean, if you do this, this will be better for you. There are also dispositional factors, so juvenile status and mental impairment. Okay? It's been shown that juveniles are far more likely to falsely confess. Of the first 208 DNA exonerations in the US, 35% of the false confessions were 18 years or younger and or had a developmental disability. And there's lots of factors at work here. For instance, an inability to grasp some of the rights that are read to you. For instance, the Miranda rights, where people are told that they have the right to remain silent, they have the right to an attorney. Oftentimes people who are young or who have kind of mental impairments are unable to kind of grasp exactly what that amounts to. And interestingly, innocence is often connected to false confessions. If you have nothing to hide, you oftentimes will sit down and talk. You'll waive your Miranda rights to an attorney. You'll start kind of having a lengthy conversation with the interrogators, and they'll start trying to trap you into minor inconsistencies. I now want to shift gears and talk about the phenomenon of testimonial injustice, which has received a fair bit of attention across disciplines in, let's say, the last maybe 8 years. So testimonial injustice is classically regarded as having 3 kinds of factors that go into it. The first is where you get less credibility than you deserve, so you suffer from a credibility deficit. And it's the result of a prejudice on the part of the person who's giving you the credibility deficit, and it's one that targets your social identity. So a very intuitive, classic example of testimonial injustice would be a woman who goes to report a sexual assault at the police station. She is not believed because the police officer is sexist and believes that women lie about sexual assaults. Okay, so that would be an example of the woman getting less credibility than she deserves. There's no good reason. There's no good reason for the police officer to be doubting her. It's just the result of his prejudice, okay, his sexism, and it targets her social identity, her identity being, kind of being a woman. And so when this prejudice tracks a subject through different aspects of their life, it's said to target their social identity in this sort of way. So, obviously, like I'm a professor, but that we might say is not an identity that tracks me in all of the aspects of my life. If I'm in the bakery, being a professor doesn't matter at all. But my being a woman, for instance, tracks me through all of the different dimensions of my interactions. And that's the kind of social identity that when people are talking about testimonial injustice, they tend to have in mind. Miranda Fricker, who I know you guys had out, I believe, a couple of maybe talks ago, says that when someone is the victim of testimonial injustice, what happens is they're wronged as a knower. Okay? So one way of understanding this is that if I can't be a giver of knowledge in my communities, if I can't convey things because I'm not believed, because I'm doubted, okay, I'm regarded as unreliable or not credible, then I'm wronged in my ability to be a member of the knowing community, of the community that gives knowledge, right? And so it's widely accepted in this literature that only getting less credibility is relevant or is connected to testimonial injustice, okay? And so the idea is that if you get more than you deserve, you're not being wronged. There might be some downstream or long-term consequences of getting more, right? So suppose that, kind of people are always like, you're just, you're in a community in which everybody says, go talk to her, And so in the long run, you might be burdened with a lot of labor because people might be constantly coming to you, for help or for, advice. And you might develop certain vices over time because of this, like you might become really immodest, okay, or arrogant, but you're not wronged in that instant. And one of the things that, one of the reasons for this view that it can only be deficits is that credibility is regarded by many people in this debate as being an infinite good. So if I have a pizza and I only have a certain amount of slices, if I give more to some members of the community, then there's less for others. And so there's sort of a wrong in the distribution, right? I'm giving more goods to some and far fewer to others. But moral praise, we might think, is an infinite good, right? It's not as though if I say, like, Martin Luther King Jr. was an exceptional moral agent, then I only have a tiny, tiny, tiny bit left over for other people. It's an infinite good. I can just give as much of it out as I want. And people in the literature who are interested in testimonial injustice think that credibility is a lot more like moral praise than it is like pizza. If I believe that you went snorkeling over the summer and you went hiking over the summer, it's not as though like I'm giving out, if I really believe you over here, I have less to believe you over here, right? There's enough to go around. And so there's also not the wrong of distribution, right? If I give more to some than others. Okay. And so one of the things that I want to do is I want to look at this phenomenon of evidence swamping in the criminal justice system. And I want to suggest that one explanation, and I think a powerful explanation of what is happening here, is that what I call the confessing self, okay? Because oftentimes when we're talking about the distribution of credibility, we're talking about two different people, right? I mean, imagine a typical accusation that somebody denies, right? The question becomes, do I believe this person or do I believe this person? But in the case of false confessions, we're talking about two different selves. We're talking about the confessing self and then we're talking about the recanting self. And we're asking, which of these two selves do I believe? And I want to show that the way that confession evidence functions in the criminal justice system is such that confessing selves get a wild kind of credibility excess, okay? And that this results in a unique kind of testimonial injustice that is due to an excess and not a deficit. Okay, so I think that we can see this as a start by looking at some features of false confessions. Okay, so I'm going to show through a couple of detailed case studies that confession evidence does three different things with respect to other kinds of evidence. It swamps other evidence, it distorts other evidence, and it's resistant to counter evidence. I'm going to return to these. Okay, so confession evidence oftentimes trumps DNA evidence. Okay, so this is a well-known case from the state that I'm from, in Illinois. So this is the case of Juan Rivera. So Juan Rivera was convicted of the rape, and I should kind of just give a content warning. I am going to be discussing some cases involving violent crimes against children. So I just want everyone to know that. Okay, so he was convicted of the rape and murder of an 11-year-old girl in Waukegan, Illinois, on the basis of his confession, even after DNA testing of semen at the scene excluded him. So the state's theory of why DNA belonging to someone other than Juan Rivera was that DNA was found in the victim was that the young girl had prior consensual sex with an unknown male, after which time Rivera raped her, failed to ejaculate, and then killed her. So there was no other evidence that this 11-year-old children can't have consensual sex, first of all, but then also there was no other independent evidence that this 11-year-old child had any other unknown males in her life. But after Rivera confessed and then the DNA excluded him, this was how the prosecution explained away the DNA evidence. And in fact, this theory is so widely used by prosecutors that it has a name, and it's called the unindicted co-ejaculator. Okay? So this is a well-known strategy that prosecutors use to explain away DNA evidence that's exculpatory. Okay, so because of trial errors and post-conviction DNA testing, he had 3 separate jury trials, and he was found guilty and sentenced to life in prison on all 3 occasions. So these were 3 separate sets of jurors, right? Jurors of his peers that convicted him on the basis of this DNA, on the basis of this confession evidence, even in the face of the DNA evidence that excluded him. And the fact that he was convicted of the child's murder shows that the state's outrageous theory was regarded as more credible than the possibility that he confessed to a crime he didn't commit. And it wasn't until the Center on Wrongful Convictions, actually at Northwestern, the university that I'm at, took his case on, that the Illinois Appellate Court ruled in 2012 that his conviction was unjustified and that it couldn't stand. And so the state dismissed all charges against him, but he had already served 20 years in prison. Second case study is that of Billy Wayne Cope. So in 2004, in the case of South Carolina versus Billy Wayne Cope, Cope woke up one morning to find that his 12-year-old daughter had been strangled to death in her bed. After 2.5 days, he confessed in a statement that was filled with contradictions and factual errors. Shortly thereafter, it was revealed that his daughter was also sexually assaulted. And subsequent DNA tests revealed that the semen and saliva found on the girl's body didn't match him, but it did match James Sanders, who was a serial sex offender who had broken into other homes in the area. The prosecutor, armed with a police-induced confession that didn't match the facts of the crime and with no evidence of a link between Sanders and Cope, charged Cope with conspiracy and theorized that he had pimped his daughter out to Sanders. On the basis of this theory, the jury convicted both of them, and his conviction was affirmed at the state level. In 2014, the US Supreme Court refused to take his case, and he recently passed away in prison. So in 2010, the Center on Wrongful Convictions identified 19 cases in which confessors to rape and/or murder were tried and convicted, despite having been excluded by DNA tests of key biological materials. And as I said, many, many, many cases don't even get to have DNA testing. Either the materials weren't saved, there's too little to do the testing, the state refuses to do the testing, and so on. Now, what I want to suggest is that the most plausible explanation for these types of cases is that false confessions receive a massive, unwarranted excess of credibility, okay? Meaning that the confessions are regarded as extremely reliable, and this is unwarranted. Okay, so one of the things to notice is that in these classic cases, where confession evidence grounds convictions, particularly in the face of counter evidence, such as DNA testing, the totality of the evidence against the confessions is often substantial, while the evidence in their favor is remarkably thin. Okay. So in the case of Juan Rivera, the evidence in favor of his evidence wasn't only the DNA evidence. He was also 19 years old, and he was a former special education student who had been questioned by detectives for 4 days during which he denied any knowledge of the crime. So recall the situational features that we saw, where it's recommended that you not interrogate someone for more than 4 hours. So he was interrogated for 4 days. Around midnight on the 4th day, after his interrogators became accusatory, Juan Rivera broke down and purportedly nodded when he was asked if he had raped and killed the 11-year-old child. The interrogation continued until 3 a.m. when investigators left to type a confession for him to sign. Minutes later, jail personnel saw him beating his head against the wall of his cell in what was later termed a psychotic episode. When Juan Rivera talks about the experience now, he will say that at this point, when he was in the middle of the psychotic episode, he has no recollection of actually signing the confession. Nevertheless, within a few hours, he did sign the typed confession that the investigators had prepared, but the document was so riddled with inconsistencies and implausible information that the Lake County State's Attorney instructed the investigators to resume the interrogation and clean up the inconsistencies. So despite the fact that he was in the middle of this psychotic episode, the interrogation resumed, and it resulted in a second confession which contained a plausible account of the crime. So in philosophy, we're often kind of, and we're looking at when someone has good enough evidence to hold a belief that's rational. It's usually kind of, well, I mean, nearly universally accepted, and this is what's so powerful, is that philosophers don't agree about a whole lot. But it's universally pretty much agreed that knowledge and rationality is incompatible with the presence of the kind of counter-evidence that is often called defeaters. Okay. And there's different kinds. So there's some counter-evidence that's called rebutting and some called undercutting. And this is counter-evidence. Rebutting targets the proposition, okay, the content of the belief, and normative undercuts the source, so the reliability of the belief, you know, kind of the source that you got it from. And then there are defeaters that are things that people believe, and those are called doxastic. And then there are things that people should believe. And those are called normative. And I think one of the things that we see is that it's absolutely clear that people at every stage of the criminal justice system had this kind of counter-evidence. Okay? So his false confession was given what I want to say is a massive excess of credibility over a span of decades, and by people at every stage of the process, including police officers, prosecutors, and jurors. And this was despite the fact that he was a special education student who had been sleep deprived through multiple lengthy interrogations, and he was in the middle of a psychotic episode. And this is relevant because whenever we are told something, we automatically, even if it's not consciously, think about how reliable the person is, right? I mean, imagine that somebody tells you, kind of, I just arrived in London yesterday, so suppose someone starts telling me where like the best Thai food is, and I find out that they've never been to London before, right? I mean, I might start to think, kind of how reliable is this person? But one of the things that's psychologically fascinating is that we don't ask how reliable someone is when they confess to something, okay? The whole idea of assessing credibility or assessing reliability when someone confesses to something is not even on the table. And one of the things that we can see is that there's plenty of evidence that Juan Rivera was unreliable about Juan Rivera's own guilt, right? Because we had all of this evidence about, kind of his status. Including, of course, that his original confession was riddled with inaccuracies and implausible information. And then, of course, we also had evidence against the belief, and this was the DNA evidence that excluded him. Now, when someone has counter-evidence, they can only kind of retain rational belief if they've got evidence that defeats that. But there is no interpretation of the state's outrageous theory, the unindicted co-ejaculator theory, that makes it more likely that the 11-year-old child had this kind of other relationship, okay, than the theory that he falsely confessed. So there's no interpretation where that functions as evidence that defeats the initial counter-evidence. Now, another way I think we can kind of see that there is this excess of credibility is by looking at numbers. So we tend to forget that oftentimes when a confession is given in these contexts, there's only one instance of testimony. And it's often given under conditions of coercion, manipulation, deception, sleep deprivation, stress, and so on. But then there is a recanting self who reports innocence hundreds, thousands of times over the span of decades. Okay? And those instances of testimony add up to be new instances of someone reporting something. I mean, think about yourself over the last 20 years, let's say, right? You've undergone radical transformation over those 20 years. What you might say at 19 is going to be very different than what you say at 39. You might think that in some respect, in some deep important sense, you're different selves. And so a 19-year-old recanting and a 39-year-old recanting, okay, adds up, okay, in ways that the court just completely ignores. So this is another kind of sort of way of conceptualizing the terrain to see what a massive imbalance confession evidence gets, right? One moment swamps decades of conflicting testimony. Okay, so what I hope to have shown is that confession evidence often swamps other evidence, so it's regarded as virtually definitive evidence of guilt. And this is shown, for instance, by the fact that the investigation usually concludes when it's given. It distorts other evidence. Outrageous theories of the prosecution are taken to be more plausible than the possibility of a false confession. And it's resistant to counter evidence. Exculpatory evidence, inconsistencies in confessions, evidence of the unreliability of the witness are all dismissed. Okay? So confession evidence has these three functions of swamping, distorting, and being resistant. So if you recall, we started off by, I mentioned how a lot of people think that credibility is much more like moral praise than it is like pizza. And what I want to suggest is that there are many of contexts in which credibility is far more like pizza than it is like moral praise. Okay? So when you have false confessions, it's not as though you can say, oh, well, they're both reliable, right? Okay? If one self says, I committed this murder, and the other self denies having committed the murder, then only one is right, right? And like as I mentioned before, oftentimes this is an interpersonal concern when we ask who to believe. But with confessions, we see that it's an intrapersonal concern, and we're asking which self to believe. Okay? And to believe one is to not believe the other. Okay? And in that respect, we can see that credibility is finite, because to give it to one is by its very nature to deny it from the other. Okay? So one of the things that I want to focus on is agency. Okay? And there's a particular conception of agency that refers to us as knowers, okay? The agency that we have as knowing agents. And that's what we might call epistemic agency. So it's the agency that we have as knowers. And one of the things that we see here is that when the state says that the reality described by confessors in cases of false confessions, one that is reported through coercion, manipulation, and so on, that represents his or her truest states, I want to say that the confessor's status as a knower is reduced to what she reports only under conditions devoid of agency. Okay. Now, I want to point out an instructive parallel. So in ancient Athens, enslaved persons were permitted to testify in judicial proceedings only under torture. Okay? So they could not give testimony unless they were tortured. So they were regarded as credible only when their testimony was extracted through interrogation techniques that undermined their agency. In other words, only when it wasn't freely given. Okay, freely given as an agent. And I want to suggest that there is something similar going on in the United States criminal justice system. That the interrogation techniques that we're using, okay, the interrogation techniques that involve manipulation and deception are undermining people's agency in ways that are instructively, I think, parallel. Okay? And then we're saying, you're only reliable when you give us testimony under those conditions. Not when you're reunited with your father, not when you have a support system in place, not when you've gotten some sleep, right? Not when you're not in a psychotic episode. Then you're a liar, right? It's only when we get the testimony from you in ways that bypass your agency that we think you're reliable. Okay? I want to say that there are two wrongs that people who experience this kind of extraction and that excess of credibility suffer. The first, okay, is through the, so I'm sorry, so just to kind of give you a characterization of the kind of testimonial injustice I'm interested in, a speaker is the victim of this kind of injustice when testimony that has been obtained in a way that denies or bypasses her epistemic agency is afforded an unwarranted excess of credibility. Okay? So again, a very kind of, simple structure is when it's extracted and then there's an excess. There are two wrongs that I think people suffer. The first involves the excess. And here one is wronged by virtue of being regarded as a testifier, a giver of knowledge, only when your testimony is extracted and is thus the product of a process that subverts your agency. Okay? So you're wronged by being regarded as a knower only when we get the testimony from you in a way where it's not freely given. And the second wrong is through the extraction process itself. Okay? So the extraction itself involves an undermining of your agency in a way that wrongs you. Okay? Now, I think that the structure I have identified is sufficient for someone to be the victim of a kind of testimonial injustice, what I call agential testimonial injustice. But some in the literature really think that it needs to involve some sort of social identity that's operative. I myself am not as committed to this. I actually think that the structure I've described is sufficient. But I do think that it's interesting to note that we can expand the notion of social identities that are operative to perhaps capture what is going on here. So Edwin Meese III famously said in 1985, while he was then the Attorney General of the United States, "You don't have many suspects who are innocent of a crime. That's contradictory. If a person is innocent of a crime, then he is not a suspect." And then we also have massive amounts of empirical evidence that show that groups associated with delinquency, deviance, or moral deficiency, such as criminals or prisoners, are frequently the targets of systematic prejudice. So one explanation of what is operative here is that once you find yourself in the interrogation room, you are immediately regarded as a suspect. And therefore, even if you don't endorse something as kind of absurd as what Meese says there, there still might be the bias that suspects already are put into a category in which they are less credible or less reliable. Now, one question that I just want to briefly address is why? Why are confessing selves given this credibility excess in the first place? And notice how crucial it is to answer this question. You don't get convictions on the basis of false confessions merely by saying that recanting selves get less credibility than they deserve. So think about the traditional model of testimonial injustice that I kind of presented to you. On that model, the only resource they have to explain what's going on here, the way in which you're wronged, is that when you deny having committed the crime, you're given less credibility than you deserve. But that's not going to be good enough. You don't get a conviction on the basis of simply denying or not believing the recantation. You have to also believe the confession in order for it to ground a wrongful conviction. Okay? And so I just want to briefly mention that there's a lot of social psychological literature on this question that has been done in the last 10 to 20 years. It's become a very fertile area of study. And one of the most compelling features that we see is that people, jurors, judges, kind of interrogators, find it incredibly difficult to get their minds around the idea that they would falsely confess, okay? They just think, I would never do that. That would just never happen to me, okay? But the problem is that there's just ample psychological evidence that shows otherwise. I'm not going to go into this in too much detail. We can spend some time talking about it during the Q&A, but I kind of want to leave ample time for that. But there's just plenty of studies that show that it's actually not difficult to get us to falsely confess to something. One I'll just cite is one of the more recent ones from 2009. And in this study, they used digital editing software to fabricate evidence of participants stealing money from a bank during a computerized gambling experiment. And when presented with this evidence, 100% of the participants signed a false confession. And one of the things that's really powerful about this is to think about actually, kind of people talking about the future spread of deep fakes online, where we're going to see increasing numbers of doctored videos of people, kind of particularly public figures saying things that they in fact didn't say. And when people see something with their own eyes, it's incredibly difficult to overcome kind of the evidential impact that has on you. We can actually see that in some of these cases, coerced, internalized false confessions result. And this is where people come to believe in their own guilt through the presentation of the evidence. So this is just a particularly powerful case, the case of Michael Crow. His sister was stabbed to death in her bedroom. And after a series of interrogation sessions, during which time police presented him with compelling evidence, physical evidence of his guilt, he concluded that he was a killer, saying, quote, "I'm not sure how I did it. All I know is I did it." Eventually, he was convinced that he has a split personality, that bad Michael acted out of a jealous rage, while good Michael blocked the incident from his memory. The charges against him were later dropped when a drifter in the neighborhood that night was found with his sister's blood on his clothing. So when he was presented with this false physical evidence, he internalized his own guilt. We also see that false confessions affect the perceptions of others, including eyewitnesses, alibi witnesses, and forensic experts. So it begets additional misleading evidence downstream. So if I tell you, kind of make sure, watch this water bottle, make sure no one steals it, and you guys all keep your eyes on it, then tomorrow I come in and say, did anyone steal the water bottle? You'll all say no, right? We watched it the whole time. And then I say, oh, well, he confessed to taking it. People's kind of ability, kind of to function as an alibi dramatically goes down after this, right? Once you hear that someone confessed to it. There's also kind of evidence of racial prejudice or bias. 85% of juvenile exonerees who falsely confessed in the United States are African American. And then there's, of course, the practical interests of the prosecution. Oftentimes, an unwillingness to admit wrong, mistakes or errors. A very well-known case. All of these cases are from Illinois. I'm assuming none of you are going to want to come to Chicago after this. So this is the case of the Dixmoor Five, where DNA evidence ruled out 5 defendants who had falsely confessed to the rape and murder of a 14-year-old girl. They served, these 5 men, a total of 95 years behind bars. All 5 were exonerated in 2011, and the Illinois State Police settled in 2013 a civil rights case brought on their behalf for a record $40 million. Moreover, the semen that was found inside the 14-year-old matched Willie Randolph, who was a convicted rapist with 39 arrests. And despite this, this is Anita Alvarez, and she was our state's attorney. And during a very famous now, infamous I'd say, 60 Minutes interview, when she was state's attorney, she said that it was still possible that the 5 defendants raped and murdered the girl, and that Willie Randolph just happened to wander past the field where her body was and committed an act of necrophilia. And that's how his semen was found in her. And this was our state's attorney. I'm going to skip this slide. There's objections you might have to the analysis I'm giving here, and I'll just let you guys raise those during the Q&A to leave plenty of time for that. And then I just want to mention that the model here is generalizable. Coercion comes in degrees, and so there are many different ways in which agential testimonial injustice may occur. I'm just going to simply mention briefly one kind of case you might think of so that you see that it doesn't always have to be tied to something like an interrogation room. Imagine that the police are called for a domestic violence case. They show up at the house. They ask the victim if she had been battered by her partner, and the partner is standing right there. Okay. He might function as a coercive element with regard to her testimony, and if her denial of having been abused is then given a massive excess of credibility, and then her later claim to having been abused is given a kind of less credibility than it deserves, this would be another clear instance of what I'm calling agential testimonial injustice. Okay, so in conclusion, I want to say false confessions provide us with very good reason for acknowledging this new kind of testimonial injustice, and it occurs because credibility can be finite, and it results when an excess of credibility is given to a confessing self in conditions that undermine that person's agency. In such cases, I want to say the state is quite straightforwardly saying to its citizens, you are worthy of being believed only when we bypass your agency and extract information from you through coercive or manipulative methods. That this is a particularly pernicious form of testimonial injustice carried out by institutions in which we place our trust, cries out for a radical change in the epistemic lens through which we view confessions in the criminal justice system. Thanks.